welcoming each and every one of you for the weekly legal current affairs for the month of July. This is part 4. In the previous sessions, we have discussed certain very important legal updates of those weeks itself. Now, since you guys are all preparing for CLAT and other law entrance examination, it is absolutely necessary for each and every one of you to understand the kind of preparation that you require for cracking this particular entrance examination. Now, as you are aware of the fact that in this particular entrance examination, one must have a good understanding of, number one, current events. Now, current legal events that have been happening plays a very important and a crucial role. That everyone must all agree with me. Now, in this session, we bring to you some of the most important events, which might be a little old events, but we are going to discuss them in a way so that each and every one of you are able to understand them. So let's start with today's agenda. We are going to talk about demonetization judgment, a 5-judge bench of the Supreme Court. What did they say about demonetization that took place in the year 2016? There was a dissenting opinion by Justice Nagaratna. We are going to discuss that. We are also going to discuss about the Chief Justice of India recently inaugurated or launched the ESCR project. What is this ESCR project? We're going to look at it. Third, Constitution does not prohibit lawyers who are practicing in the Supreme Court to be appointed as judges of the High Court. Now, there were a lot of criticism about the fact that there are lawyers who are practicing in the Supreme Court. Now, can they be elevated as a judge in a High Court? That was the we are going to see what the Supreme Court had to say on that. And finally, we also are going to discuss about a very important issue wherein it is said that the Prime Minister or the Chief Minister, who is the head of the cabinet, does not have disciplinary control. They do not have disciplinary control over the cabinet. The Prime Minister does not have a disciplinary control over his cabinet. Neither does the various chief ministers of various states have disciplinary control. We are going to understand what is disciplinary control and move on. So these are some of the things that we are going to understand in the course of this particular session. BYJU'S Exam Prep brings to you this scholarship test. So you can get up to 90% scholarship in our programs. On 22nd of January, the scholarship test is going to take place. Get yourself registered at 11 a.m. Okay, very, very important. Everyone must sit for the scholarship test. And if you get to the top rankers in that scholarship test, you get 90% discount on the courses. Moving on, many congratulations to Anika Sehgal, AIR 18 of ALIT 2023. Now, what did the Supreme Court say in the demonetization case? Now, what is demonetization? Scrapping of certain currency notes. Now, a currency is a legal tender which is issued by the Reserve Bank of India, the Central Bank of India. It is a promissory note. The RBI says, I hereby promise to give the holder of that currency worth 500 rupees. So it's a kind of a promissory note. It is a promissory note. Now, the government's decision in the year 2016 of scrapping two very important currency notes. They are the 500 rupee note and the 2000 rupee note. So the government came up with this. The Prime Minister came at 8 o'clock on one evening and said that, you have just 4 hours left. After 4 hours, all your currency notes, 500 and 1000 rupee note will be all scrapped, will be just a piece of paper. Fair thought. Now, that decision of the government of India was challenged in the Supreme Court. Now, many years have passed. Okay? Like after 6 years, 7 years, the Supreme Court decides this, whether this policy of demonetization was valid or not. What did the Supreme Court say on that? Now, there were 5 judges other than Justice Nagaratna. Everyone, Justice Abdul Nazir, Justice Gawai, Justice Bopanna and Justice Rama Subramaniam all said that this demonetization is valid. The only member of that 5-judge bench was Justice Nagaratna, who said that this process of demonetization is bad under the law. Why did she say that? What are the things that were discussed? Now, the question was whether the government has the power to demonetize a currency based without a parliamentary law. Now, the previous demonetization that happened way back after India got independent, they all took place by virtue of a legislation passed in the parliament. But here we see demonetization taking place without a law passed by the parliament. Very important. Now, whether it is valid, invalid, let's check it out. Now, under the RBI Act of 1934, the Reserve Bank has the power to demonetize a particular series of currency. So, under the RBI Act, under the Reserve Bank of India Act, the Reserve Bank of India has the power to demonetize a particular series of currency. 500 rupee note, 1000 rupee note, 5 rupee note, 10 rupee note, whatever. That power is there. Now, whether that power can be used by the central government. Now, what we saw, the Prime Minister coming and saying, within 4 hours, all monies, 500 rupee note and 1000 rupee note, throw it in the dustbin. It's of no value. Now, the question is whether this power of 26 can be used by the central government. Now, the Supreme Court interpreted that, what does the law says? 26(2) says the central government may declare any series of banknote the central government can declare based on the recommendation of the central government, RBI, the central government can declare. The word any must be interpreted as all. That is what the Supreme Court said. A lot of debate on it. The crux of the matter is simply this, that the power to demonetize a currency is there under the RBI Act. But was it used in the right manner or was it not used in the right manner? The principal question is this. Insofar as the Supreme Court, what did the Supreme Court say? The Supreme Court said that the power is to be used only on the recommendation of the RBI. The power to demonetize a currency which is given under the RBI Act can only be used based on the recommendation of the RBI. Now, the question is, was there any kind of recommendation from the Reserve Bank of India? Now, the Supreme Court says that power can be used only upon recommendation of RBI. The power to demonetize can be used only on the recommendation of the RBI. Parliament and state legislature may not have specialized knowledge. Technical and situational intricacies are better left to expert executive bodies and specialist public servants. Now, the Supreme Court over here very categorically states that as judges, as legislators, people might not have that much of technical knowledge about when to demonetize, how to demonetize and all. It should be left to specialist bodies. Mere possibility or eventuality of abuse of power in the absence of any evidence supporting such claim cannot be a ground of striking down the entire process of demonetization. Now, there were a lot of things in the air. There was no evidence on record, but people perceived that, it was the decision of the central government. Fair thought. But was it done on the recommendation of the RBI? People had no knowledge of it. It also said that you cannot strike down a policy just based on certain allegations. There has to be substantial grounds, substantial evidence on it. Relating to policy and guideline test, the Supreme Court said that theory of policy and guidelines assume that the legislature cannot always perform all its legislative function. Therefore, it has to delegate them. Now, certain powers are given to the legislature. Now, the parliament is open only for a couple of days. And that's the reason you have delegated legislation. That means the power to legislate is delegated to someone else. It is done. While the delegation of power is a reality, such delegation cannot be of uncanalized and uncontrolled power, and the delegation will only be valid if the legislature has set the limit to such delegated power. Now, what is the power of the delegated legislator? Those contours have to be categorically stated. Legislature can set the limits to delegated power by declaring the policy of the law and laying down standards for guidance to those on whom the power to execute the law is delegated. So that is what the Supreme Court said. The Supreme Court also relied on Gwalior-Rayan as well as Roger Matthews' judgment relating to the validity of this particular policy of the government of India. So the Supreme Court relied on two judgments, Gwalior-Rayan's and Roger Matthews, for this thing. Not very important. Now let's see what the Supreme Court has said. The decision-making process is not flawed in law. What? The decision-making of demonetization. So the demonetization process is not flawed by law. Duty of this court is confined itself to the question of legality and to determine whether the decision-making authority exceeded its power, committed an error of law, committed a breach of the rules of natural justice, reached to decisions which no reasonable tribunal would reach, or abused its power. The court is not concerned with the manner in which the decision was taken. The court was only concerned about the fact whether the decision was legal or whether the decision was illegal. Whether the decision can be founded under the law or not. The court, it's not the duty of the court to get into whether the decision is right or wrong. It is up to the executive to decide. The Supreme Court said that the court does not have the expertise to go into the question whether the object with which demonetization was effected is served or not. Mere errors of government, on the part of the government are not subjected to judicial review. Only palpably arbitrary ones are declared void. Only if an order or a decision is arbitrary in nature, only then can the Supreme Court declare it void. Now, relating to the test of proportionality, the Supreme Court said that it is designated for a proper purpose. The measure undertaken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. Measures undertaken are necessary. They are to alternate measures. There is no alternate measures. Now, this is very, very important. Now, there has to be a proper relation between the importance of achieving a purpose. Now, the Supreme Court said, the government made various statements saying that, we wanted to curb down on terrorism, black money and all. Now, whether it was achieved or not, it's a different thing. The Supreme Court is only concerned with the legality of such a demonetization order. Now, the Supreme Court said that the purpose of demonetization was elimination of fake currency, black money and terror financing. There is a reasonable nexus between the measure of demonetization with the purpose of addressing issues of fake currency banknotes, black money, drug trafficking, and terror financing. Court does not possess the expertise to decide what alternate measures could have been undertaken. There is a proper relation between the importance of curbing the mania of fake currency, black money, drug trafficking, and terror financing, and demonetization of 500 and 1000 rupee note. Even if they were reasonable restriction, it was in the larger public interest. So the 4 judges sitting there along said that this policy, which was effectuated to stop terror funding, black money, and you also had fake currency, drug trafficking money, and all these things. The idea of the government was not bad, but whether it was done in the legal manner or not, the Supreme Court is to answer. The Supreme Court said the manner in which they had done it, it's absolutely perfect. The 4 judges, that is, Justice Nagaratna does not decides in the other way. The Supreme Court also says that assuming holding note is a right under the Constitution, the right vested in the notes were not taken away. Only restrictions with respect to exchange of old notes with the new notes. So it was not a case wherein entire money has to be thrown away. There were certain restrictions. Every person can only deposit 1,50,000 money in their accounts, only not more than that. So people did it. So there was certain restriction. It was nothing like all your money has gone to the waste paper basket. No, it was nothing like that. So there were certain restrictions that were imposed on this during this demonetization. Moving on, before we move on to the academics part, BYJU'S Exam Prep brings to you CLAT 2024 comprehensive course. There will be 300 recorded videos across 5 sections, 300 hours of live classes, 35 mocks, monthly e-magazine for current affairs, and these contents are all based on the extensive analysis of the last 5 years of CLAT question paper. Moving on. Further, the Supreme Court says that if the time for such exchange are not limited, the high demonetization banknotes could be circulated and transferred without the knowledge of the authorities concerned for one person to another, and such transferee would have demand exchange of their notes on any subsequent day. Thus, the very purpose of demonetization would be defeated. So there was an argument that shouldn't it be done after demonetization, should be done after people are aware of it for at least a week or 2, so that they can take precautions. Now the government said that if I had told that, after a week I'm going to demonetize this currency, by then everything is over and out, right? Okay. Now, the dissenting judge, Justice Nagaratna, what did she say? She said that the central government has the power to demonetize all series of banknotes of all demonetization. If the need of such a measure arises, it cannot be restricted in such powers in such manner as the central board of the bank is under the above provision. This is because such power is not exercised under subsection 2 of section 26 of the Act, but is exercised notwithstanding the said provision by the central government. Therefore, demonetization of banknotes at the behest of the central government. Now, the dissenting judge very categorically says that, very clearly says that the power to demonetize the currency is there with the government. Fair thought, no problem. But it has to be based on the recommendation of the Reserve Bank of India. She says that there was no recommendation from the Reserve Bank of India. Since there was no recommendation from the Reserve Bank of India, this demonetization is bad. Moving on. The Supreme Court, in a wake to adapt with technology, has launched this fabulous project called the Electronic Supreme Court Reports. The eSCR project will provide a digital version of all Supreme Court judgments. So all the Supreme Court judgments can be found in the e-Supreme Court reports. Now, you can just search a particular phrase and you can get a number of judgments. So it's a great search machine, free of cost, that the Supreme Court has launched. Now we have Manupatra, we have SCC Online. There are various portals which provide search engines insofar as Supreme Court cases are concerned. Now, this is a step towards giving the lawyers, young lawyers, free of cost, a particular search engine which is going to help them in their research of legal cases. So this is a fantastic project which was inaugurated by the Chief Justice of India, Justice Dhananjay Yashwant Chandrachud. Now, what can you search? There is a free text search, there is a search within search, case type with year, judge search, year and volume search, bench strength search options. So across the board, you find various search engines that have been provided by the eSCR project. That's a very good thing. It's a great initiative by the Supreme Court. So what did the Chief Justice of India say? This is a free service available for lawyers across the country, so young lawyers do not have to pay. There is an elastic search facility. We are improving upon the search engine by incorporating the followed, distinguished and incorporated judgments in few weeks. As of now, the judgments are up to 1/1/2022. I have given a deadline of 15th February for judgments of 2002. Also head noted, with effect from today, all judgments will be placed online within 24 hours. The access will be placed on mobile app, which we have launched, and also on National Judicial Data Grid. There are around 34,000 judgments. We are also introducing a neutral citation. Delhi and Kerala High Court already have it. So that is what the Chief Justice of India had to say during the launch of this particular thing. He also said that the SCR project will be available on the Supreme Court's website as well as on the National Judicial Data Grid, and ECR can be accessed on this particular web link. Okay, judgments.ecourse.gov.in PDF search. So this is the particular thing. Moving on, the third important judgment. The Constitution does not prohibit lawyers practicing in Supreme Court to be appointed as judges of the High Court. Now, a number of lawyers who practice in the Supreme Court, they are directly elevated to the Supreme Court, like you had Justice Rohington Nariman, former judge of the Supreme Court, former Chief Justice of the Supreme Court, Justice U.U. Lalit, Justice P.S. Narasimha. So there are a number of examples of lawyers who were practicing in the Supreme Court and they have been elevated as judges of the Supreme Court. Now, a number of vacancies arises in various courts across the country. And the Supreme Court of late, and it's a practice that a number of lawyers who are practicing well in Supreme Court, they have good knowledge, judges know, they are appointed as judges in high courts, right? Calcutta High Court, Madras High Court, Bombay High Court, Jodhpur High Court, Rajasthan High Court. Now, whether it is permitted under the Constitution. Now, what does the judge say? Constitution does not prohibit lawyers practicing in the Supreme Court to be appointed as judges of the High Court. In suitable cases, advocates practicing in the Supreme Court can be considered for elevation. As a High Court judge. Am I clear? So a person who is practicing in the Supreme Court can be elevated to the bench in a state High Court. Am I clear, everyone? Before we move ahead, BYJU'S Exam Prep brings to you a scholarship test. If you get that scholarship test well, what you get if you do well in that scholarship test, if you qualify, you get a 90% scholarship on the BYJU'S Exam Prep products. We provide 1-year courses for CLAT, ALIT, Maharashtra CET, Symbiosis. All these examinations are covered. On 22nd of Jan, remember the date, on 22nd of Jan at 11 a.m, we are having this scholarship test. Sit for it. And if you get selected, you get a 90% off on the products offered by BYJU'S Exam Prep. Moving on. Now, insofar as appointment and condition of office of a judge of a high court is concerned, what does the Constitution say? The Constitution of India very categorically say that every judge of a high court shall be appointed by the President after consultation with the Chief Justice of India, the Governor of the state, and in cases of appointment of judge other than the Chief Justice of the High Court. Every judge of a high court shall hold office in the case of an additional or acting judge as provided under Article 224 and in any other case until he or she attains the age of 62. So here you see that every judge of the high court shall be appointed by the President. So the President is the appointing authority in consultation with the Chief Justice, Governor. Okay, so this is a collegium. The collegium system appoints judges. Now, does Article 217 anywhere says that, a person who is practicing in the Supreme Court cannot become a judge of a high court? No, that is what it is. Is that clear? Now, resignation, how is a high court judge gives his resignation? He gives his resignation to the President because the President is the appointing authority. The person who appoints you can only take your resignation. A judge can be removed from office by the President of India. How? Very difficult. Office of the judge shall be vacated by the being appointed by the President to the judge of the Supreme Court or being transferred by the President to any other high court. So there is a transfer of judges. So a high court judge of Delhi can be transferred to some other courts. Other courts can be transferred to some other courts. So there is transfer policy of high court judges. Of course, there can't be any transfer policy insofar as the Supreme Court is concerned because there is only one Supreme Court. Right. So now, what is the qualification of a judge of a high court? Very important. Citizen of India. At least 10 years of practice as a judicial officer, as a judge, district court, or at least 10 years of practice as an advocate. So, either 10 years as a judge in the district court or 10 years. This is a qualification. After everyone might have been had 10 years, put in 10 years as an advocate or judge. Doesn't mean that everyone will become a judge of the high court. It is based on the based on how the collegium sees that gentleman insofar as his knowledge, insofar as the arguing skills. Everything is to be taken into account. How many cases did he argue and henceforth everything else. So Justice Call simply says the method of recommendation envisaged under the collegium of the High Court to recommend the name consisting the Chief Justice and 2 senior most judges. Whatever the government inputs, including the IB obtained and the Supreme Court collegium of the first 3 judges after obtaining inputs from the consulting judge takes a call. There is nothing, very, very important, there is nothing in the Constitution which provides the prohibition for lawyers practicing in the Supreme Court to be appointed as judge of the High Court. In fact, every lawyer is enrolled with the Bar Council for a particular state. Every lawyer. Just because you are practicing in the Supreme Court cannot disqualify you from being in the genre of being considered as a judge of the High Court. Finally, the next important legal development. Neither the Prime Minister nor the Chief Minister of a state have disciplinary control over members of the Council of Ministers. That is what the Supreme Court had to say. The Prime Minister or the Chief Minister does not have disciplinary control over the members of the Council of Ministers. A statement made by a minister, even if trackable to any affairs of the state or for protecting the government, cannot be attributed vicariously to the government by invoking the principle of collective responsibility. The concept of collective responsibility is essentially a political concept. It is a political concept. So, if a minister is saying something, you cannot tomorrow hold the government responsible. If tomorrow the minister has said something wrong, has said something bad, can you hold the Prime Minister responsible? Answer is no. That is what the Supreme Court said. Collective responsibility is that of the Council of Ministers, and such collective responsibility is to the House of the People, Legislative Assembly of the state. It is not possible to extend the concept of collective responsibility to any and every statement orally made by the minister outside the House of the People or Legislative Assembly. So you cannot hold the government responsible for the wrong words that are being told or being said by a particular minister. Justice Rama Subramaniam had to say in this particular regard that as all the literature on this issue shows, collective responsibility is that of the Council of Ministers. Each individual minister is responsible for the decision taken collectively by the Council of Ministers. In other words, the flow of stream is collective responsibility inform the Council of Ministers to the individual minister. The flow is not on the reverse, namely from the individual ministers to the Council of Ministers. Very important. The flow is not on the reverse, namely from the individual to the Council of Ministers. It is from the Council of Ministers to the individual ministers. Very important. It is true that in practice, a strong Prime Minister or Chief Minister will be able to drop any minister out of the cabinet. But in a country like ours, where there are multi-party system and where coalition governments are often formed, it is not possible at all times for the Prime Minister stroke Chief Minister to take the whip. Whenever a statement is made by someone in the Council of Ministers, governments which survive on wafer-thin majority, of which we have seen quite a bit, sometimes have individual ministers who are strong enough to decide the very survival of such government. This problem is not unique to our country only. So the Supreme Court here is lamenting on this particular issue that for certain words which have been stated by a particular minister, the government cannot be held responsible. Because the collective responsibility is only of the minister to the Lok Sabha and the Rajya Sabha and the legislature. And now we have seen coalition government. Now, in what happens in coalition government, there will be one minister from one party. If he withdraws, if he says something wrong, and if the Prime Minister or the Chief Minister asks him to leave, then he might make the treble. The government might treble. He might take off his support from the government, and the government is over, because we have thin majority government these days also. So that is what the Supreme Court was lamenting upon. So guys, BYJU'S Exam Prep brings to you these very important sections which are going to give you a great support insofar as your preparation for CLAT and ALET is concerned. Do subscribe to our YouTube channel. Do follow us on our Instagram, like our page on our Telegram. Do join our Telegram group. Do like our Facebook page, and definitely do not forget to download the BYJU'S Exam Prep app. So get your app today downloaded. Okay. So guys, with this, we come to the end of this session. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Have a great evening ahead. Bye-bye. Take care. Thank you.